Hi, everyone, and welcome to my presentation on the international case of Gray versus RSPCA. The country of origin is the United Kingdom. The docket number is CO/10303/10. It is being presented by me, Chelsea Melendez, and it is for St. Petersburg College for the class ATE 3515 Legal and Ethical Issues in Veterinary Technology. Some background information about the case before you get into the facts. The case was heard at Queen's Bench Division and Administrative Court of the United Kingdom with His Honor Judge Tyver and 2 magistrates. Some background information about the applicants. The principal claimant, Mr. James Gray, used to be a horse trader. His business was carried on at Spindle Farm, Chalk Lane, Hyde Heath, and Amersham, which I believe are some villages in England. In this case, 4 other members of Mr. Gray's family, including his wife, were found jointly guilty with him on some of the charges. Michael Fullerton and Richard Sherrill were some attorneys that were both instructed by Nigel Weller & Co. that represented James Gray and Julie Gray. Robert Seabrook, QC, and Ian O'Donnell were the attorneys instructed by Paris Smith for the interested party. Background information on the respondent. The RSPCA stands for Royal Society for the Prevention of Cruelty to Animals. They are the oldest and largest animal welfare charity in the UK. Their primary goal is to promote animal well-being. They advocate rescue and care for animals that are in need. Some more about the RSPCA's work. It basically includes rescuing strays, campaigning against cruelty, providing pet care advice, helping injured wild animals, certifying animal welfare on farms, and volunteering. They have been involved in many notable campaigns and legislative changes over the years. This includes, in 1998, the banning of cosmetic testing on animals, 2004, passing the Hunting Act, which protects wild animals from being hunted by dogs, 2006, the passing the Animal Welfare Act, which made significant changes to animal welfare law. 2016, making it mandatory for dog owners to microchip their dogs. 2019, banning wild animals in circuses in England and in Wales in 2020. In 2021, passing the Animal Welfare Sentencing Act, which increased prison sentences for animal cruelty from 6 months to 5 years. Some facts about the case. The case originated on November 20th, 2007, when Neil Harris of the National Trust, which is a heritage and nature conservation charity and membership organization in England, had discovered horses on National Trust land without permission. There was evidence of animal neglect, malnourishment, and deaths that were reported. The Crown Court heard from about 40 witnesses, not including the veterinary surgeons that were sent by the RSPCA officers, where they revealed severe malnourishment, deaths, and horses that were found in poor conditions, including equine decomposing carcasses. The examinations revealed the likely causes of the deaths and their suffering. Disputes arose regarding ownership, care, and responsibility of the animals between the appellants and the authorities, and 11 charges were made against Mr. Gray. Some more details about the charges that were placed against Mr. Gray. Charges 1 and 2 were related to animals whose dead bodies were found on the farm decomposing. Charge 3 was related to an animal who had to be euthanized due to its poor health conditions and considering its future quality of life. It was found that the animal suffered unnecessarily by being neglected and starved, and where the animal was housed, it could not get to food or water. Charge 4 was related to 13 horses who suffered unnecessarily by failing to provide them with an appropriate diet. They were neglected and also left to starve. Charge 5 was related to a pony who suffered from an infection of the penis, which had already been progressing for so long. The pony needed to be euthanized. With proper treatment, the pony would have survived, but Mr. Gray never took the appropriate steps for the pony to be seen by a veterinarian. Charge 6 was appealed. Charge 7 was related to a horse who was euthanized due to an infected eye and chronic diarrhea, mostly related to a poor diet and related to not getting proper veterinary care. Charge 8 concerned a donkey foal who was starved to death and was suffering from salmonellosis. Charge 9 was related to a few ponies and equines where the veterinary surgeon orally authorized their seizure due to the fact that it was noticeable that they were not properly cared for, and they were taken away and basically placed under authorities that could give them the proper care until everything was resolved in court. Charge 10 was appealed. Charge 11 was related to animals who were very thin and weak and also very close to death. For some legislative context about the act that was used in this case against Mr. Gray, it is the Animal Welfare Act, placed in 2006. It is a legislation in England that aims to protect animals by placing a duty of care on owners and keepers. Now, what does this law of this act actually mean? It means people basically must ensure good practice of animal husbandry and care. Those responsible for animals should provide a space that meets the animal's physical, social, and psychological needs, provide good nutrition and a suitable diet, the ability to exhibit normal behaviors, house with or apart from other animals, protected from pain, suffering, injury, or diseases. Some sections of the Animal Welfare Act that were used against Mr. Gray include section number 2, protected animal. This basically states what a protected animal means under the act. Quoted from this section is of a kind which is commonly domesticated in the British Islands. It is under the control of a man, whether on a permanent or temporary basis, or is not living in a wild state. Section 2, including with section 3, which is responsibility for animals, they basically state what an ownership of an animal is and basically whose responsibility it falls under. Quoted from section 3 is, in this act, references to a person responsible for an animal are to a person responsible for an animal, whether on a permanent or a temporary basis. Section 33 is deprivation. Quoted from the section, the court, by or before which he is convicted, may, instead of or in addition to dealing with him in any other way, make an order depriving him of ownership of the animal and for its disposal. Section 4 is unnecessary suffering. Quoted from this section is, a person commits an offense if an act of his or a failure of his to act causes an animal to suffer. B, he knew or ought reasonably to have known that the act or failure to act would have that effect or be likely to do so. Part C, the animal is protected. And Part D, the animal suffering is unnecessary. Section 9, duty of person responsible for animal. Quoted from this section, Part 1, a person commits an offense if he does not take such steps as are reasonable in all the circumstances to ensure that the needs of an animal for which he is responsible are met to the extent required by good practice. Section 18 is powers in relation to animals in distress. Quoted from this section, Part 1 is, if an inspector or a constable reasonably believes that a protected animal is suffering, he may take or arrange for the taking of such steps as appear to him to be immediately necessary to alleviate the animal's suffering. Issues and judgment about this case. One of the issues that were brought up during this case is the interpretation of knew or ought reasonably to have known in Section 4, Part 1b. The expression quoted knew or ought reasonably to have known is an expression that is commonly used in English law. A person may argue that by using this expression in quote-unquote appropriate terms, basically the defendant would have to know that his act or omission would or was likely to have that consequence. Mr. Fullerton, on Mr. Gray's behalf, asked for required proof or knowledge that the animals were in a condition of causing unnecessary suffering or showing signs of suffering that could not be missed by a reasonable and caring owner. The court included that an objective test can be held so that the defendant's conduct will be assessed. Another issue that was brought up in this case is the lawfulness of the seizures on 4, 5, and 9 January 2008. The horses were seized in support of Section 18 of the Welfare Act. They were seized by police officers acting on the oral statements made by veterinary surgeons. They considered it necessary for the general protection of their well being. After they were seized, they went for physical exams and samples taken for analysis to be used for this case. Mr. Gray made a submission saying that the evidence was inadmissible and unlawful due to the fact that there was no written certification of a veterinary surgeon for the animals to be seized. But the court responded by saying Section 18 did not require the process of a certification and rejected this submission about the seizures. Another issue that was mentioned in the case was that cost orders should not be grossly disproportionate to the fine. In the case, Mr. Fullerton submitted that the court was being basically unfair for charging Mr. Gray a charge that was disproportionate to the fines. The fine stated under the act that was being used against him basically explained that the maximum fine that could be imposed under each offense under Section 4 is £20,000, and for the offense under Section 9 is £5,000. So for the 7 Section 4 offenses being charged, it should not have gone over £140,000. And for the 2 Section 9 offenses, the maximum should be £10,000. The Crown basically confirmed that they rejected the submission because they were entitled to make a balanced judgment. And for their reasoning, they used Criminal Procedure Rules 2010, Part 76.2 to back up their statement. And due to the complexity of the case, the time spent on the case, the parties who were involved, and to compensate the prosecutor, they thought the cost of the charges were appropriate. And another issue of the case was whether the appellants are criminally liable for the neglect and mistreatment of the animals in comparison to each individual's role. Basically, the evidence that was presented by expert witnesses and authorities supported the conclusion that the animals suffered due to malnutrition, parasitism, and neglect. The role of each person was determined with evidence, and their statements about their ownership also clarified what their role in the situation was, and the evidence of the conditions of the animals. For the rationale, the court relied on expert testimonies, veterinary reports, and physical evidence. Contraindications in the appellant's statements, lack of proper care for the animals, and the severity of their conditions led to the court's decision. The appellant's attempt to shift blame, deny responsibility, and discredit the reports from the experts that witnessed the condition of the horses were not accepted by the court. For disposition and analysis, the court held the appellants accountable for the mistreatment of the animals and held the charges under Section 4. The animals were seized and placed under the care of proper authorities to promote a healthier lifestyle. Mr. Gray was banned from keeping horses, ponies, and donkeys for life, while his wife, son, and daughters were banned from doing so for 10 years. He has already been ordered to pay the RSPCA £400,000. In my opinion, I agreed with the court's decisions. I think they highlighted the significance of following animal welfare law really well. And I think that they held the right individuals accountable for their actions. And I also supported their judgment of the cost of the charges, because I think with the amount of actions that needed to be taken to get the horses out of the situation that they were in, the amount of people involved, and the work that the RSPCA put in, I think that they deserve that justification, and the RSPCA as the prosecutor deserves to be compensated for all the work that they did for these horses. And then this is my works cited, And I just wanted to thank you for watching my presentation.